Well, good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show on Facebook, YouTube, um, and maybe Twitter as well. My name is Sandy Chen. I'm an employment lawyer here at our firm's Vancouver office. We have offices in Ontario and Alberta as well. I'm here for the next half an hour or so, and I'll be answering any and all questions to do with employment law. So if you have issues in the workplace, if you have issues with your contract, issues with your boss, issues with a colleague that maybe isn't being so nice, or if they're harassing you or bullying you, anything and everything, severance pay, if you're being discriminated in the workplace. So I can't see anybody, but hopefully everybody can see and hear me. But if you just type your questions into the text box in front of you, I should be able to see them on my screen, and I'll just go in the order that I see them. So while we wait for some questions to come in, I did have a few topics that I want to discuss today. Some topics old and some topics new, but people who've seen me on here before will probably have heard of some of this stuff. A recent trend I'm seeing in the files that or the cases that and the people that I've talked to, is that their employer, whether it's a corporation or a partnership or whatever, is being acquired and or being merged with another company. Right, we had that huge Rogers and Shaw merger. I think it was last year, and so there's always a lot of craziness and a lot going on whenever something like that happens, especially in the bigger mergers like that, right? People, some positions are made redundant, people are being let go, and so there's a lot going on, and there's a lot of uncertainty, and if your position, if you're working at Shaw and Rogers has a team already doing your job, it's probably it's a very precarious situation for you, right? And so there's a few key points I wanted to hit on about what happens when a merge and an acquisition happens. Number one is obviously you might be kept on by the new company, right? And one of the issues that comes up is the new employment contract. And so if you're, because technically at law, sometimes through these mergers and acquisitions, your employment is technically considered terminated by your previous employer, right? And so and that triggers severance pay. But the new employer will a lot of times have you sign a contract, and some key terms to look in that contract, I find, to really from an employee's perspective to protect yourself is recognizing your length of service with the previous company, right? Making sure that the severance provisions, if they do decide to let you go, make sure that your previous years of service are recognized. Make sure the severance provision doesn't limit you to something, like a week or 2 weeks notice or something like that. That's important. Obviously, make sure the position and your duties and all that stuff are something that you would agree to. And so that becomes kind of something to look out for, right? If the new employer presents you with an employment contract. Now, a common situation I've seen a lot is when the new company that's taking over your previous employer will give you a position that's somewhat different, right? It's not exactly the same as your previous position. There's some changes. And that becomes kind of a tricky issue because, if you were a vice president before, now they're just making you, maybe demoting you to a director level position. There's a question of whether you're legally obligated to accept that, right? And by legally obligated, I mean, obviously you don't have to take it, but if you don't, can you still get severance, right? And so that's something else that I see a lot nowadays with, a lot of the smaller companies being acquired. So yeah, I mean, and sometimes it's actually not the new company you go after for severance pay, right? It's actually the previous employer. depending on the nature of the transaction. And so if sometimes if it's just what we call an asset purchase as opposed to a share transaction, I won't get into that too much, but you're legally considered to have been technically terminated by your previous company, and they're the ones that are on the hook for the severance pay. And so just things to look out for. But I see we've got some questions here. So the first one's from Anita. Anita's asking, you've been an employee at your work for 30 years. They are relocating. You do not drive. You have received a paper saying that there's a job offer in Waterloo for you. You have not signed it. You're currently on WSIB because you had a reverse shoulder replacement last April. You've been told that you will have permanent modified duties. Your physio and WSIB have told you to work to travel is 45 kilometers approximately. You're 62. Can you give me some more information, please? And thank you. Yeah. So Nia, there's quite a few issues going on in your situation there. So the relocation is the first issue I see. It's there's so in general, an employer is not permitted to move your location of work to someplace really far away, right? And it's kind of a matter of degree. And so they can't move you from, wherever you are. Let's say it's Toronto to Calgary, right? But maybe they can move you from, down the street a few blocks, right? And so if it becomes a really far commute, that's not a term you have to accept. And there's a recent case I'm thinking of where I think there's an Ontario case where someone was asked to move from Belleville to, I want to say somewhere near Kingston, but it was about 50 kilometers that the employer was asking the employee to move, and the court found that was not acceptable, right? And so what the legal term for that is, it's called a constructive dismissal, where an employer is kind of unilaterally and fundamentally changing a term of employment, right? And that term in your case would be the relocation. Now, the one exception I've seen is if you've signed a contract that says they're allowed to move your location of work by X amount of kilometers or, within a certain geographical area. So you've got to watch out for that as well. And so depending on how much further that commute makes you, or how much further that commute is for you, you could have a claim for constructive dismissal. Now, what does that mean? A constructive dismissal essentially means the employer has fired you without explicitly saying that you've been fired, right? And that would entitle you to severance pay, right? Assuming you're not in a union. If you've been there 30 years, you're 62. Those are important factors in arguing for a bigger severance package. And so a court will look at your age, your length of service, your position, right? How easy it'll be for you to find a new comparable job. And just based on two factors of your age and 30 years, I'd say you're probably close to, if not, 24 months of severance pay, right? That's generally the maximum a court would award an employee for severance. And so, yeah, I mean, for your case, that's an option, right? Where it becomes a bit more tricky in your case is you're on WSIB benefits. And so if you're on WSIB, that I assume you're on you're currently on an unpaid medical leave, and you when you go back, you'll have modified duties. This doesn't change the fact that they can't, in general, the employer can't move your location of work. What it does change is the severance pay, right? Generally, you can't get double compensated through severance and WSIB. So it becomes a bit trickier in that scenario. But I would encourage you to speak with an employment lawyer at our firm. It sounds like you're in Ontario, so you can speak to one of my colleagues there and get a consultation to see what they can do for you. Because anytime, and if you're on a medical leave, there's issues of accommodation, right, that the employer has to make efforts to accommodate your medical condition to the point of undue hardship, which means they have to try their best. And so if they let you go for because you're asking for accommodations, there could be a discrimination case as well, right? So Anita, a lot going on in your case there, and I strongly urge you to before you speak with your employer again to get some legal advice on the best path forward. And if what you want is severance to kind of end your employment there and just be paid out, I think that that could be a viable path in your situation. All right, we've got another question here, or sorry, follow up from Anita. You forgot to mention they have certain travel radiuses. You were not offered a severance package, and the date for relocating will be August 1st, 2024. I think that if they're not terminating your employment in they're not going to voluntarily offer you a severance package, right? It might take legal counsel or someone like me to get involved to actually get that severance package, unfortunately. And so I think it's critical that before August 1st, or as soon as possible right now, that you go get some legal advice in your situation, because these constructive dismissal cases are tricky, right? Some maybe moving your office 2 kilometers is okay, but obviously there's been cases that say 50 kilometers moving the office is not okay. So next questions from Sir on YouTube. You're asking, do all employment disputes go to the Supreme Court for claims over 35,000? Can this go to arbitration instead? Yes, good question. So in general, yes. So all employment disputes go to Supreme Court for claims over 35,000. Now, there are exceptions, as with anything in the law. So if you have a discrimination case, you have to go to the Human Rights Tribunal. If you're provincially regulated, there's a provincial Human Rights Tribunal, the BC Tribunal. If you're federally regulated, so if you work in banking, or if you work in a trucking company that does interprovincial deliveries, you would go to the Canadian Human Rights Commission. And so, and if you're federally regulated, there's actually another process that you go to the Canadian Industrial Relations Board for what's called an unjust dismissal complaint. The general rule is anything over 35,000, you go to Supreme Court, but there's quite a few exceptions. With respect to your question, can this go to arbitration instead? Yes, it can. Now, arbitration is generally mandatory if there's an arbitration clause in your contract, right? Again, there's a few exceptions, but if there's no arbitration clause in your contract, there's nothing stopping you and the employer, or if you're the employee, or if you're the employer, you and the employee, from voluntarily agreeing to do an arbitration, right? It's faster. There's more confidentiality. Sometimes it's cheaper. But yeah, I mean, it's definitely something that you can do, whether voluntarily or if it's mandated by the contract that you signed. If anybody has follow-ups, please, if I didn't completely answer your question, just please feel free to just kind of type a follow-up, and I'll get to it in order here. Next question is from Jeff. You're self-employed. You accepted a 3-month contract for a senior director role. Verbally promised a renewal. You were shut down. You shut down your self-employment business and worked beyond the contract. Okay. In month 5, you were let go. The contract became indefinite. So how much severance are you entitled to? Yeah. So good question, Jeff. So it's hard to say with just those facts that you've given me, right? Like I mentioned before, how old you are matters, how senior that senior director role matters, right? How long it takes you to find a new job matters. The fact that you restart your own business right after that matters as well. And so I don't have a definitive answer for you. I mean, just because you were short service doesn't mean you get nothing, obviously, right? I've seen 5-month employees get up to 4, 5, 6 months of severance pay. Um, the fact that you were promised a renewal and they reneged on it, maybe there's something there with respect to pursuing them for the renewal, right? So that because they represented that to you, maybe you can sue them for sue them to enforce the renewal, right? However long that renewal may have been. And so there's a few different key factors in your case there, Jeff, that I just don't know, and I wouldn't be able to give you a good answer. But just because you're only there 5 months doesn't mean you get little to nothing for severance, right? It could be a substantial amount depending on other facts. So if you want to clarify on those points I just made, maybe just let me know how old you are and how long the renewal would have been. And is it possible for you to just reopen your own business, right, and start making some money? Okay, we've got a 2-part question from Sherry. You're dealing with a PIP. You've challenged because there were unwarranted claims and evidence of discrimination. HR is considering revoking it. And then part 2 says, should you stay to maximize your earnings and aim for a better severance later, or negotiate an exit now? Can you still negotiate effectively after raising these issues months later? Yeah, sure. That's a tricky situation. So, I mean, I've dealt with many cases where the employee and employer negotiate a mutual separation package, right? They have not, as far as I can tell, they have not technically let you go. And so technically you're not entitled to a severance package right now, right? And so I would almost think that you can negotiate more effectively after they've let you go, right? Because right now they haven't let you go. You're still technically employed. So you don't have as much leverage in general, right? There could be other factors in your situation I don't know about, unless, if they really want you out of there or you really want to get out of there. Like, I mean, it's not a bad idea to negotiate now, but all things being equal, an employee has more leverage after they've been let go, right? Again, there's maybe things I don't know about in your situation that makes it better for you to negotiate now and just get out of there. And maybe you can if you're in BC, you can come talk to me about them privately, or you can talk to one of my colleagues if you're in another province. But if they decide to let you go, right, because of the PIP, and they say it's for cause, and there's clearly no cause, and these accusations were unwarranted or they have no merit, that could potentially entitle you to extra compensation on top of your severance package, right? So a court sometimes awards employees what's called extra contractual damages. So if an employer doesn't act in good faith and they don't act honestly towards you, there could be additional compensation there if they do decide to let you go ultimately. In terms of maximizing your earnings and for a severance package, I mean, yeah. So your earnings, your severance package is based on typically recent earnings, right? And so maybe you can clarify your question a bit, but if you're going for part-time to full-time now, then yeah, your severance package should be based on full-time, and maybe it is a better idea to stay there and work full-time. And so, but if your earnings have stayed consistent for the past while, right, I don't see, and they're going to stay the same for the next few months, and I don't see how that comes into the picture. Can you still negotiate effectively after raising these issues even months later? I don't see why not. It's they happened, right? And your case will only get your case may only get stronger if they actually do decide to let you go because of these unwarranted claims and this PIP that they put you on. But again, Sherry, your situation, I will say it's very nuanced. There's a lot of things I don't know, and so I think it's better to consult with a lawyer and give them all the facts in a private consultation to kind of to figure out what the most effective strategy is, right? Because a lot of times it's not just the legalities that come into play. There's emotions, the psychology of all this stuff, and it's hard to kind of talk about that in this forum. Next question is from Vanessa, is asking you, since you informed your employer that you're pregnant, you've been assigned a additional work that is not part of your regular job. You've voiced complaints. Nothing appears to be changing as you're understaffed. What options do I have? The additional workload is exhausting. Yeah, so Vanessa, that goes to my earlier point about this concept of a constructive dismissal. It's not just constructive dismissal. It's not just changing your jobs or moving your location of work really far away. It's this all-encompassing term that it really covers a lot of situations, right? And it does certainly cover yours. If the employer is making you do additional duties, they're fundamentally changing your job, right? Instead of doing 30 hours a week, maybe you're doing 60 hours. That's clearly a fundamental change that you don't have to accept. And so I'll say to you what I said to, I think it was Anita earlier. You have the option, right? If it's really a lot of extra work you're doing for the same money, you have the option of rejecting it and saying this is a termination of employment and getting some severance pay. And so I understand that might be, it may not be the best option if you're planning on going on maternity leave soon. And so again, something to be aware of. But at the very least, I think you should put something in writing to the employer that says I'm not accepting this additional workload. And the other part is, if you're getting all this work, I don't know what the reason for this would be, but if you're getting all this extra work because you're pregnant and they're just trying to push you out of there, right? That's discrimination under the Human Rights Code. So questions from Mohammed. You're in Ontario. You're working with an employer doing mobile mechanic, and then he rented half a shop to buy and sell cars and fix it for him. You got injured when you were working on the second car. You lost your tools, which cost over $60K when I bought them. If you want to buy them now, it costs $100K. The second one was harassing me and didn't pay me for the work I did for him. I called the police on him after threatening me. You contacted WSIB, and now you're not able to work because of your lost tool. What are your steps? Yeah, why did you lose your tools? I just clarify that part. And are you is this the same employer and you're just doing two different jobs? I think you made the right call in contacting WSIB if you have a workplace injury, which it sounds like you do. WSIB should be covering you for at least part of your income loss, right? And so you're gonna have to clarify this tools part a little bit. I'm just rereading your question here to make sure I didn't miss anything. And the second one where someone's harassing you, didn't pay you for the work you did for him. I mean, that's just a breach of contract, and you can sue. I don't know if this is a customer you're talking about or the employer that isn't paying you, but if it's your employer, you go to the employment standards branch, or you can I'll refrain from saying too much. I'm not 100% sure on the Ontario forums, but I mean, if someone's not paying you for work you did, you can pursue legal action against them, right? In Ontario, I think you can pursue it in the courts or through the employment standards branch. Jordan's asking, your landlord's giving you 24 hours to notice to enter your suite. Considering that, does an employer have to accommodate you with time to go deal with tenancy related matters at home. Yeah, Jordan, I'm not actually 100% sure. I don't think so. I'm not sure that is a protected leave under the Employment Standards Act or under the BC Human Rights Code. But I guess if it's, I mean, with the tenancy related matters at home, I don't think so, unfortunately. Okay, so we got a follow up from Sherry. You've only been with the company for 10 months and you are waiting on a bonus, but you're worried that the employer can argue that they mitigated the issues of discrimination, diminishing your leverage. Well, I mean, nothing prevents you from, if there's discrimination at work, you don't have to be fired to file a claim, right? You can file a claim with the Human Rights Tribunal right now if there's been discrimination at work. I mean, in terms of them mitigating the discrimination, yeah, I mean, if you give them the opportunity to do that, they could lessen your leverage technically, right? But it's, you know, and obviously if you're still employed there, it's kind of uncomfortable if you file a complaint against them at the same time that you're working for them. I get your point about the bonus. I mean, it's depending on the size of the bonus, it might be better to wait until you get that bonus. And so, yeah, I mean, there's ups and downs of waiting, right? And with the discrimination issue, you know, just because they've mitigated it doesn't mean that they don't have liability. Although if they give you an apology and fix the problem, then, you know, it does diminish your leverage in negotiations. But I mean, I guess it's good in the sense that they've addressed the discrimination, right? Okay, so another question here from Dennis. Sign a contract with salary and a bonus when you started your current position a few years ago. Your manager approached you with a new salary agreement and bonus plan to sign a few days ago. But with a lower salary, are they allowed to lower your salary? Yeah, so Dennis, they're not. And depending on how much they're lowering your salary, it could be a constructive dismissal, right? The magic term I've been referring to a lot today. I would say anything more than a 10 or 15% pay cut, it's probably something that entitles you to claims for severance pay and your employment. But again, you should talk to a lawyer before, or do a private consultation before you take any drastic steps. The one exception in your situation is I've seen contracts that actually allow them to change your bonus plan and your salary, right? And so something else that needs to be considered and looked at. So Randy, your follow-up is there? I'm sorry, is this a follow-up? Your question is there anything you can do being self-employed? I'm not sure that I think this is a new question. I mean, if you're self-employed, is there anything you can do with respect to what issue? Just clarify that. Mohammed, you're asking, your second one didn't allow you to go into the shop and you had to get one of your customers to pick up the tools, and he said he sold them because you did a bad job. And the first one didn't contact me to get it. I work with 2 employers. Yeah, I mean, it's the fact that one of your customers sold them, that's something you can sue the customer for, right? You work with 2 employers. There are no contracts between them. Okay. So hopefully that answers your question, Mohammed. Yeah, there's legal recourse for you, right? If someone sold your property and now you've incurred costs in replacing them at a higher cost, right? That's something you can sue. Okay, so I'm just gonna double check. There's no follow-ups. Oh, one more, last one by Jordan. If they change by 10% and later do it again, would that be allowed, or is it a constructive dismissal? Yeah, that's a good question, Jordan. I don't. It's an interesting question because I'm not sure I've seen a case with a situation like that. In my view, if they change it by 10%, right, you should object in writing and say you don't accept this 10% change. And then when they do it again by 10%, that's 20% now. And so that's clearly a constructive dismissal. Theoretically, if they change it by 10% now, you could sue them for breach of contract, right? For that 10% that less you're getting paid. Whether that's something that's ever happened, or if I know a case of that happening, I don't think so, because it's generally awkward to sue your employer if you're still working with them. But yeah, if they change it by 10% and then 10% again, then I would say all else, being equal, it's probably considered a constructive dismissal. The issue is if they change it by 10% this year, right, and they do it by next year, they could argue you've accepted the 10% by continuing to work, and so it becomes a bit of a tricky situation. If you're in BC, Jordan, just come talk to me about it, or one of my colleagues if you're in another province. Okay, so I don't think I got to everyone today, and I apologize for that, but that's all the time we have for today. My colleague is on, I believe, either tomorrow or next Friday. I'll be back in 2 or 3 weeks, and so if I didn't get to anybody, please feel free to contact me. And thanks everybody for joining. Hope everybody has a great day and a great weekend.